Very good. So again, a very warm welcome from the Child-Friendly Justice European Network. We are a network of 19 organizations across 17 European countries with the role of promoting child-friendly justice across Europe and really making sure that every child that is in contact with justice system, being it in civil, administrative and criminal proceedings, but also when we talk about access to justice, access to legal remedies, we want to make sure that every child has their rights respected and that professionals working with them understand that children are at the center in their rights, and that systems should adapt to the needs of children and not the other way around. So I see here again that people are welcoming and saying some words where they are from. So welcome everyone. And I would like to say just a few words before introducing the panel about what are we going to talk about today. So how much do words matter when we talk about child-friendly justice? So according to authors Hollins and Kruppert, who in April 2022 very recently released a publication on language as a protective factor, they mentioned that shifting terminology is important to lessen the stigma and promote children's well-being when a parent is incarcerated. This publication that was specifically written about the situation of children of imprisoned parents is actually making people aware of the importance of making conscious word choices when referring to this group of children to avoid stigmatization and the negative impact that this can have for children in their development and their future life. So in this interesting piece of work, they are trying to answer the question, does our language uphold an oppressive system? And echoing this, Children of Prisoners Europe, a sister organization, network organization across Europe, has also been very interested in the way we use words, that practitioners, policymakers use words. When referring to children, we talk about convicts, inmates, offenders. So they have been developing 10 key messages, about to address policymakers in shifting the language. And in this, they are highlighting 3 points. One, that it's important to avoid reductionist statements and to also involve children when developing messages that are affecting children. There is also the importance of fostering the agency and empowerment of children instead of fostering victimhood. So the language in that, it's a very important factor. And also, of course, focusing on the positive change that we want to see instead of the actual situation that the child is in. And also the use of adjectives that actually defines an identity of a child. So if we think about this, and we have General Comment 24 of the UN Convention, of the UN Committee on the Rights of the Child, that is the body to help us interpreting the Convention on the Rights of the Child. So General Comment 24, which is entitled Children's Rights in the Child Justice System, replaces General Comment 10, which was published in 2007, who still refers to juvenile justice. So there has been an evolution, as the committee has recognized since 2007, in standards, practices, legislations. So, and there has been also the use of juvenile justice, and that comment recommends to shift in the English version from juvenile justice to child justice. And what is particularly interesting is that the previous version of the General Comment, before the one that was published in 2019, was also referring and defining juvenile justice. It was also defining children in conflict with the law and making reference to acknowledgements of positive developments in the use of language to reinforce dignity and worth of children. So to that end, what I'm asking here, all of you, and especially the panel, is how respectful and humanizing is the language used today by practitioners and policymakers in the child justice field? Do we need to be contemporary in using words and concepts? So in order to answer these questions, and maybe you can bring all your questions about the language of terminology, we have here a very exciting panel, interdisciplinary panel, and I would like to present them to you. I'm happy to have here with us Benoit van Kersbeek, who is member of the United Nations Committee on the Rights of the Child. Benoit has a degree in social work and children's rights and is currently director of the Belgian section of Defense for Children International. Benoit has been president of the International Movement of Defense for Children from 2013 until 2017. Benoit was director for 25 years of the Service des Droits des Jeunes in Brussels and co-director of the Interdisciplinary Center for Children's Rights and chief editor of the Belgian edition of the Youth Law Journal. Benoit is a high-level speaker in numerous conferences across the world and gives frequent trainings in the area of children's rights. Welcome, Benoit. Dr. Astrid Posialowski is a psychologist by education and training. Astrid is the head of the Social Rights Sector and Equality, Roma and Social Rights Unit of the European Union Fundamental Rights Agency. Astrid previously held academic research and teaching positions in Europe, but also in New Zealand and the USA. Astrid has been the project leader of several international research projects and played an active role in the development and update of the FRA Handbook on Children's Rights, which was published in 2022, which contained a wealth of resources on case law and legislation in Europe. Welcome, Astrid. We have Dr. Robert Schwartz, Bob, who is a visiting scholar at Temple University Beasley School of Law. Robert co-founded the Juvenile Law Center in Pennsylvania in 1975 and was its executive director from 1982 to 2015. This center is a non-profit public interest law firm that uses the law to ensure that youth in the foster care and justice systems are treated fairly and have opportunities to become productive adults. Robert represented dependent and children who committed an offense in the Pennsylvania Juvenile and Appellate Courts. Robert brought class action litigation over institutional conditions and probation functions. He testified in Congress before House and Senate committees and has spoken in over 30 states on matters related to children and the law. And Robert is a key specialist on adolescent development. Welcome, Bob. We have Pippo Costella, who has a degree in philosophy and who is the founder and current director of Defense for Children International Italy. DCI Italy is an active board member, Pippo is an active board member of the Child-Friendly Justice Network. Pippo has worked on childhood and adolescence development programs with various NGOs, international agencies, and institutions in the Middle East, Southeast Asia, and Europe. Pippo's experience is focused on the development of strategies and programs for the protection of children from different forms of exploitation and abuse, programs and initiatives aimed at children. Welcome, Pippo. And last but not least, we have Michael Ha-Ryong-Yong, who is a human rights lawyer specialized in children's rights and child protections, particularly in the field of justice for children, with a current geographical focus in Southeast Asia. Michael is technical advisor of the Cambodian Child Rights Coalition and legal officer at Legal Aid of Cambodia. Michael leads the Child-Friendly Justice Network in Cambodia and recently led the development of a terminology guide on child-friendly justice. Welcome, Michael. And with this round of presentation, I'm happy to open now officially this debate panel. And we will start by looking at Benoit here on my screen. And I'm asking you now, after this introduction, what word is for you particularly meaningful when we speak about child-friendly justice, and why does this word matter to you?
Many thanks for the introduction, Mariama. Indeed, I've chosen the word children in conflict with the law. One of the difficulty, and you mentioned the change of language in the General Comment 24 from the previous one. One of the difficulty is to try to define a child who is suspected, accused, or convicted of having committed offenses, and to avoid reducing this child to the offense or crime that he has committed or he may have committed. First of all, if we use the terminology children in conflict with the law, It's in a way a strange wording, because we are considering that a child is in conflict with a legislation, although he's probably in conflict with the authorities, is in conflict with some legislation that prevent him to act in some specific ways. But this child is not limited to the act that he has committed, an offense or crime. Maybe he hasn't committed it, it's only suspected. Maybe he will be tried later on, but we know that he has also the principle of presumption of innocence. So if we take all the dimension of this situation, we can notice that it's very difficult to find the right wording concerning a child who is in the child justice system because he may have had committed an offense. So when we talk about children in conflict with the law, it is as if we consider that he has committed the offense that he is suspected of, and we are putting in the same basket children who are suspected and children who are convicted. So this is my example of the difficulty to find the right wording, the right approach to talk about a child, and we don't want to consider him only through the lens of the offense that he has committed, but we also want to see that this child may also be a victim of some crimes. He may have opportunities in life. He may and he should have the possibility to have his own future without being labeled for all his life as being in conflict with the law. So that was my wording, the difficulty to find the right name for this kind of children who will not limit or reduce them to their crime. That's what I'm proposing to discuss later on. Thank you.
Thank you very much, Benoit. So indeed, so about finding the right words, I mean, now, Bob, what do you think about that? What would be your words that is particularly meaningful to you? And why does this word matter to you after listening to Benoit? And maybe on mute, I think the microphone is muted.
Old problem. Thank you. Thank you, Mariama. And it's really the tension between the word that I grew up with, juvenile, and the point that Benoit is making about how we shouldn't be defining our clients or the children we're advocating for by the labels we attach to them. So, early in my career, as you mentioned, I represented children in court. Later, I worked to change policies and practices across the United States. My history informs the way I consider the word juvenile, and it's that word that I really want to focus on now. Even though when I practiced law, we would never refer to our clients as juveniles. It was dehumanizing. Words matter, or people wouldn't be on this webinar. They affected how we represented our young clients. So we would refer to children or youth. We would do that in our writings and in our court pleadings and in talking with the media or with government officials we were trying to influence. That was the easy part. But we were not only representing individual children in court, we were trying to change the systems that harmed our clients, that treated them unfairly or that failed to give them safe pathways to adulthood. We were dealing with juvenile courts. We were dealing with juvenile detention centers. We were trying to end the juvenile death penalty in the United States. We worked to end what we called JLWOP, juvenile life without parole. Words matter, but it is just as important to spend time trying to change systems that the words represent. So context matters. In the US, for example, the general public knew what a juvenile court was. The general public understood it when we attacked the juvenile court or when we sued juvenile detention centers. In 1999, when America was celebrating the 100th anniversary of the juvenile court here, there were people who wanted to treat all children as adults and eliminate the juvenile court entirely. In response, there was an organized campaign by many of my colleagues and us at Juvenile Law Center to save the juvenile court. I had friends who wanted the campaign to be about saving and renaming the court. They called for saving the children's court. I would have been happy if there was a name change, but the general public had an image of a juvenile court and wasn't going to rally around saving a children's court that it had never heard of. As I said, context matters. Changing language has to be strategic. We have to know our audience. Efforts in the United States to change language are something of a mess today, in part because people realize words matter. Some of my influential colleagues don't want to use the word juvenile. Some don't want to use the word justice. Some don't want to say legal. They don't like the word juvenile for obvious reasons. They also believe that the system isn't a justice system or isn't a legal system of the sort to which we aspire. So they speak of a juvenile legal system or a youth justice system or a youth legal system. Very few speak of a children's system, in part, I think, because advocates here are also trying to extend the system, the justice system for young people to those who are over 18. There's an emerging adult movement who should get the benefits of the children's system. So there are variations all over the place. Who gets to decide what language we use? It'll probably be a lot easier elsewhere in the world for those on this webinar. But here we have 50 states plus Washington, D.C., each with its own juvenile justice system. We don't have a convention on the rights of the child or a general comment, which makes uniform use of the word child. We advocates have limited resources. It would take an enormous effort of mobilizing to change both federal law passed by Congress and the laws in each of the United States. So while I'm happy to support dropping the word juvenile, and I love what Benoit and the committee has done with the general comment, spending too much time worrying about language in a way is a young person's luxury. At my age, I have less time. Now, I worked to end the juvenile death penalty, not rename it. I work to end juvenile life without parole, not rename it. The sad truth is that even nicely named systems can do great harm. In my city of Philadelphia, we had a brutal detention center that was called the Youth Studies Center. It wasn't the name that created the harm, but what happened inside the building. So words do indeed matter. They do influence public perceptions, policies, and practices. Let's never call children juveniles, and let's change the word when opportunities arise. But let's also think strategically about where and when and how we spend our time. Language is important, but it should be part of a larger strategy to eliminate harm and promote child well-being. Thanks, Mariama.
Thanks you so much for bringing in this insight and indeed raising our attention about, you know, how much time do we need to spend into shifting terminologies. Well, in fact, I understand from the work that has been done by the committee, and also we are getting some interesting comments now, and I will come back to the comments in the chat in a while. Why is it important to do so? So how to find the right equilibrium between shifting terminology and having action done for the benefits of the children. So before we go further in the debate, I would like to give the floor to Astrid now to see what is your words, what word is meaningful to you, and why is that word meaningful to you?
Thank you very much. Yes, I would like to refer to a word that matters to all of us who are working in the area of rights of the child, or children's rights, and this is the term child and children. So according to Article 1 of the UN Convention on Rights of the Child, a child is every person younger than 18 years of age. However, we find different terms used by experts and in daily language. There are 3 points that seem to make it difficult to consistently use the term child and children when we talk about persons younger than 18 years of age. One refers to the term minor, and I saw already a comment in the chat on this. The second to the term youth, and the third to the gendered pronoun of referring to a child. So I would like to start with the term minor. This is a term frequently used in legislative files of different languages, and as a consequence, also frequently used in English. So minor to what? In relation to when children reach adulthood in the national legislation, But the definition of adulthood can also differ. For example, when it comes to voting age, or in case when children get married before having turned 18 years. So already legally speaking, this term is not as straightforward. And if you look at it linguistically and psychologically, we should really consider what message we want to convey when we want to talk about a person as being a minor. Minor to what? The fully developed, reasonable, knowledgeable adult? So from our side, we are working on not using the term minor in any of our publications and translations. A child is every person below the age of 18 years. And this brings me to another term, which is the term of youth. And here we have, again, a problem. The age brackets are very unclear when the age of youth starts and when it ends. Here's really no consensus in international European standards, what those age brackets should be. So for example, in the UN, the most references refer to young people aged 15 to 24 years of age, whereas the Commission, the Council of Europe refer in their policy files to the age range of 13 to 30 years of age. Eurostat, for example, presents data for children up to the age of 14 and then from 15 to 29 years of age. So the starting point of using youth is often linked to legal minimum age requirements or the school system, and those differ not only between countries, but also within a country. It depends whether we talk about criminal responsibility or when it is possible to sign a contract, or till what age parents need to give their consent for medical interventions. In our latest research that we did on the implementation of the Procedural Safeguards Directive for children as suspects or accused persons, our interviewees found it at first funny that in our information letters we approached them as children. In German, for example, they found it very strange to not be addressed as youth, Jugendlicher, which actually directly translated would even mean juvenile. So considering that they were like 14, 15, 16, 17 years of age. But once we explained to them why we do not use the term youth in our written communication to them, the information letters, the informed consent procedure files, that is because the specific protection they have a right to applies to all persons up to the age of 18 years. And actually, after this explanation, they had no problem with this anymore. So therefore, we at FRA try not to refer to youth when presenting our findings and our opinions, but specify the age brackets that we look into. And when we want to address a wider age group reaching into adulthood, for example, when we look into the challenging transition phase, for example, for children deprived of parental care, we refer to children and young adults. So everybody above the age of 18 years, but below 30, we try to speak about young adults. And there's another observation I want to address and that I've been making, that is the pronoun people may use when referring to a child in singular. In several languages, the article for using the term child is masculine. For example, l'enfant in French. So what happens easily that speakers with different mother tongues than English refer to he or him when they talk about a child in general, which we then, as listeners, easily and unconsciously associate with the picture of a male person. And I think there are two solutions across languages. First, we try to use the plural children as much as possible. And second, if the speaker or author would like to or needs to refer to, from legal context, to child in singular, we see that we consistently use he and she when we refer to a child, also in the translations. Or even better, we start including the term they or another term to acknowledge gender fluidity and the discomfort persons may have who, for example, identifies queer, trans, asexual, or intersex. So yeah, I hope I, again, also as my pre-speakers gave some food for thought and discussions, and I'm happy to listen to the further input. Thanks.
Thank you very much, Astrid, for bringing in this perspective on the actual word child, and also bringing in an interesting element that maybe also we can introduce for the debate, the importance of the way that we translate certain words in concept, I guess in cultural context, but also in other languages. So before we go in the debate, I want to also go back to the audience to say, please use the chat and continue to share some of your thoughts with some words that you consider are important, and we can actually bring it in in the debate. So write down there some of the words that you consider important or questions to the panel, and we'll get back to that. So I will now give the floor to people to see what word for you is meaningful, why does it matter?
Thank you very much, Mariama. Thanks everybody for the interesting comments. When I was asked to think about a word, it came to my mind two words that are really connected. And trying to respond to the question, how much do words matter? They matter, of course, but in some way, sometimes words are proposing things, sometimes they are hiding things. So I think it's important to see what is the concept and the perception of these words behind, the lexical terms that we are going to use, especially because we would like to have an intention on words which is transcultural. And we know very well that certain language, as already was noted, have different, meaning for the same words. So they matter, but they are, a dynamic dimension. So in some way, what I'm suggesting is, as a general comment, is that sometimes they can be very formal and refer not in a sufficient way to the substantive phenomenon behind the word. So the two words that I had in mind working in children's rights for many years is the first one is vulnerability. We are using vulnerability very much. Sometimes we refer to children just for the vulnerability in a very static way. We are not considering vulnerability as a dynamic dimension, and we tend to label children with vulnerabilities instead of recognizing their story and their peculiar situation. So vulnerability is overused and sometimes is intended as a kind of sickness. No, and in fact, is a dynamic dimension we would like to intend with vulnerability. Sometimes using the word vulnerability exclude the possibility for recognizing resources and participation or agency or self-determination. So I would be very careful in using these words because sometimes it's really stick to the child and not to what is around the child, before the child and after the child. Unfortunately, we see a lot of communication also promoted by NGOs who are promoting vulnerability instead of promoting children. This is very much related with humanitarian marketing, where we are seeing children for their vulnerabilities without understanding why they are vulnerable. Who is responsible for that? And I think we have a big responsibility on that as an organization. We know that they are more effective. It's very effective to show vulnerabilities, but at the same time, we have to consider what kind of narration and what kind of identity it provides to the child and children. Sometimes we have children that we saw on YouTube with no story. They are just a scar. They are just a sickness. They are just a problem. So in some way, this vulnerable dimension is disconnected from the reason why a child becomes vulnerable. And the second word is very much related. Actually, a person is vulnerable proportionally to how much the context is making his or her vulnerable. And so the second word is context. When I refer to context, I refer to its etymological nature. Context means weaving. It describes a kind of interlinked nature. So we are not considering enough context of children. And sometimes we know very well that also the juvenile justice context is something that makes children vulnerable in itself. So in some way, I think that the word context proposes a systemic dimension which has an epistemological sense. We tend to divide and fragment our reading of the situation of children without considering that context is important, the connection between elements. Sometimes we tend to concentrate on this vulnerability without considering that is the context to make this person vulnerable. And we avoid, by concentrating on vulnerabilities and on the child, we are sometimes avoiding to, or we omit to consider that that child is vulnerable for very precise responsibility. In some way, we tend to consider the child in a fragmented way because we are not considering, for example, the convention as a systemic platform to understand what is the best interest or to analyze the phenomenological situation this child is in. So I think that these are the two words that I would like to propose: vulnerability and context, as words that recall cultural responsibility of whoever work on children's rights. Whoever work on children's rights in terms of regiving or providing all the time a context to each child in his diversity, in the diversity of his story. Without that, I think children would be all the time vulnerable, and we could be considered part of the problem and not part of the solution, also by the words we are using and the concept behind them. Thank you. I hope it makes some sense, and thank you very much for the opportunity.
Thank you very much, people, for reminding us indeed, and the way we use the vulnerability and maybe vulnerabilities and how maybe it contributes to yes or no, maybe the stigmatization, and indeed the importance of context. And here I think is also a good transition to ask Michael actually about context. I mean, people, you are talking, of course, from the perspective we are based in Europe. Michael is based in Cambodia and Asia. So if we think of context and the use of terminologies, is it actually important which region we are in? So Michael, what word is important for you? What is meaningful for you? And why is it meaningful for you? And also linking to what Astrid said, do you think that the translation of these words in other concepts, in other languages actually matters or has an importance? And why I'm asking you this, because you recently work on developing a terminology guides around child-friendly justice. And maybe you could share with us one or two words about that process and how easy it was or not to develop this guide, if I understand in English and Cambodian. And sorry, Michael, just to say, because I see that my colleague also here, and I see the chat is very dynamic, so I will also synthesize a few of the comments made, but my colleague just created a world with Mentimeter. We could create a word cloud of the words that matter to you, the words that are expressed, so don't hesitate to put your words also here in the chat to create this. So welcome, Michael.
Wonderful. Thank you so much, Mariama. And thank you to all of our colleagues who have made wonderful remarks about these very important issues. So I think I'll just build on some of the inputs that were thrown into the floor from our colleagues, and then I'll link it back to the guideline that Mariama mentioned, which our Child Justice Network have developed with the support of a wide array of stakeholders, including actually some colleagues from this room as well. So first, as a lawyer, I think naturally, looking at it from a legal perspective, we know that every single word is important when it comes to the law. You know, it decides what's justiciable, what is not, what's required and what's encouraged, for example, by using the word shall versus should. And of course, who can be processed by the criminal justice system. And a very sort of short example of that term, minimum age of criminal responsibility. We have a very clear example of that in Cambodia. Because the age of criminal responsibility is set at the age of 18 years, but that's actually interpreted to be the age at which a person can be tried as an adult, whereas the minimum age of criminal responsibility is the age of 14. But because of that very similar terminology that's used, there's a lot of confusion as to what this actually means. And we see that often across, different legal systems with similar terms having different legal meanings, which, gives rise to the importance of taking the effort to have a common understanding of these different terms. But then sort of shifting back to the normative framing and implications of that, of different terminology as we've been discussing so far. So one example that came to mind immediately when I thought of this was I was at a meeting where we were discussing the provision and support of legal aid for members of the LGBTQIA+ community. And one of the delegates in the room had mentioned, how are we able to kind of think about these specialized forms of support when we don't even have adequate support for quote unquote normal people? And so this term normal, as you can imagine, there were gasps in the air of people kind of thinking, are we actually talking about, who's normal and who's not normal anymore? Although, I think most of us understood that that speaker wasn't actually intending to mean it in that manner. But, that, short example kind of shows how terms, concepts, and mindsets can be normalized in society, and they seep into our subconscious and get reflected in the way that we speak, even if that's not what we're actually intending. So, if we're to stick on the word normal, of course, there's who defines what is normal. Is everything that doesn't conform to that framing abnormal? And the standard will be different across contexts, cultures, and communities, as we've been discussing so far. And isn't that kind of divide what exacerbates discrimination, stereotyping, societal norms like gender norms, sense of superiority and sensitivity, and a slew of other issues? But if we were to think of it, as Astrid had mentioned, if it was a result of differences in linguistic backgrounds, for example, it's very possible that we may be accidentally using certain terms in English, thinking that it carries the same connotation as in our own language, and that perhaps would mean the same thing if we were using it in that context. So going back to a term that was introduced previously, the word juvenile may be seen as neutral when it's used in languages like French and Spanish, also from a legal and etymological perspective. But in English, it has developed to often be accompanied by negative association from a layperson's perspective, in large part due to the portrayal in the media and the common usage of the term, often used in combination with terms like delinquent, criminal, super predator, etc. Another thing to consider in a similar vein is, some of these concepts don't even exist in other legal systems, like the word status offense, for example. So this definitely complicates discussions when different people are using different terms without that common understanding. And of course, as has also been mentioned by people, there are different ways of translating the same word, or it may be translated in a certain way out of convenience. Or it might just be that different contexts are not catching up to the sectoral developments where the terminology is constantly changing. So for example, going back to the idea of the LGBTQIA+ community, the term SOGI-esque, how initially it was SOGI, and then it became SOGI with an E, and then it became SOGI-esque. From where I'm from in Korea, we normally translate that to a single word that can either be translated in English as a sexual minority or a gender minority, but we use the same word for it because that initial word for sexual and gender is the same word, could be the same word in Korean, although we can also distinguish it. But that hasn't really caught up yet to the full SOGI-esque, and so we're a bit slower in that regard. So kind of linking that back to the guideline that Mariama had mentioned. There are actually two different ones. Before this current guideline, I also worked on a separate practical guideline on legal aid for persons with disabilities. And I know there was some conversation about that in the chat already. But in that guideline, we also had a separate annex on preferred terminology and glossary when it came to the disability sector. But the more relevant one today for children is the Child-Friendly Justice Terminology Guideline that was developed by Child Justice Network. And that was developed to promote the wider use and proper understanding of child-friendly terms in relation to child justice. And most of the terms that have been raised so far in this webinar are also addressed in that guideline. And the reason it was developed was because we were often hearing people using terms insensitively, but not intentionally. As I've mentioned, they just might not be aware of the connotations or the development of the sector, or maybe they were not fully understanding the term itself, which, as I mentioned, can lead to legal complications. So from the very beginning of developing this guideline, we decided to develop in both English and the Cambodian language of Khmer. And so for the English version, we integrated the voices from different linguistic backgrounds from around the world. So we've had people from different contexts kind of giving their inputs into these different terminologies in terms of what's preferred, what to use and what to avoid, as well as their understanding of what some of these terms mean. And then for the Khmer version, it was further contextualized to Cambodia to ensure relevance and a facilitated understanding. So for concepts that didn't really exist in Cambodia, we would reframe it so that it makes more sense for a Cambodian audience. And we would use terms that made more sense from a child-friendly justice context. And one of the important aspects for us was to make sure that we were targeting not just justice system stakeholders, not just government stakeholders or legal practitioners or service providers, but also to be tackling translators and interpreters, news agencies, and all these other entities that really have a strong impact on the way we're framing these discussions in the public discourse as well. So I'll leave it at that, and then I look forward to further conversations.
Thank you very much, Michael, for giving us that perspective from your end, and indeed the importance of translating the words. I mean, if we are talking about minor in English, where we had been presenting a few minutes ago, indeed in French, the terminaire is very much used, and Italian is very much used. So indeed, it's in comparison with what Astrid was actually mentioning, and the work of practitioners on a day-to-day basis actually would also need to be involved in this discussion, reflection about how aware are they of the words that they use when a law text actually uses the words. So you cannot always have a practitioner saying we would use other words that might not be defined in the law. I see now that Benoit is raising their hand, so I give you the possibility to react here, and also we can do a round now, a bit of reactions to what has been said so far, and I would also then like to raise your attention of some of the comments. I don't know if all of you have managed to look at the chat, but there are some reaction about the use of acronyms and warning about the fact that not defining children by using acronyms that is done, the importance and maybe negative impact of media, how media is perpetuating certain stigma, the fact that Bob, in one of the presentation of your work, there are words that are used as delinquent children in some of the presentations of the role that you have carried out in the past. And also that it's important to think of the logic behind the terminology use and avoiding the reinforcing stigma. And as Michael mentioned, the fact that there are some parallels that are being brought by some of the audience about disabilities. So if you want to react about any of this, please do. And now we start with Benoit. Benoit, but maybe the connection, I have a feeling, collapsed because the image froze. So I don't know if I don't know if Benoit is still with us. If not, maybe until Benoit reconnects, does any of you, Astrid, Bob, or people, want to react to what has been just said by the other panelists? Astrid, yes, please go ahead.
Yeah, I would like to pick up from one word in the chat, which is advocacy, and yeah, one has to kind of be aware which community one belongs and how one can kind of contribute to these developments in the discussions. And I also think the work with media is really important. I'm just thinking of another term, which also in the field we are working is the German word used for refugees, which previously was quite diminutive, how it was the term as such. And then there was a lot of discussion to change the word. And now everywhere in the media, you will not see the previous word. And this was happening quite quickly. So yeah, so also with the EU legislation and like consistent use of the term children since 2018, that even though if maybe in the national legislation legislation, another word is used to really promote to work in the other direction. And then still, when we talk about it, it's possible, even if there's a legislation called that refers to minors, that doesn't mean that I have to kind of talk about this group of children, for example, that are targeted in the law. I can still use the word child.
Thank you, Astrid, and for bringing this perspective. And now we have also Benoit that is back with us. So Benoit, while you were reconnecting, Astrid was sharing with us also words such as advocacy and refugees. And maybe I think you wanted to intervene based on what you have heard.
Yes, thank you, and sorry for the interruption. We heard a lot of very interesting comments, and thank you for all this. I would like to refer to the French author who had written and made research on the mystifying function of the language. So the way we call something will mean something. And in Belgium, for instance, we will talk about the youth protection law, meaning the legislation which applies to children having committed an offense. And we will talk about a youth protection center instead of a detention center, as if calling things in another way will soften the reaction or soften the approach. As if a child who would be placed in this youth protection center would feel that he is not, or she is not, in detention. Of course, when we ask children, they will say, no, we are in a prison and we are detained. But still, should we call it detention center or prison for juvenile? I'm not completely sure either, because we also want to make a difference between a prison for adults, and we would like that the place where children are locked up at one point do not look like prison for adults, and that the aim of deprivation of liberty is reintegration, education, and trying to bring the child in a better situation for his or her future. So this is another example. I wanted also to refer to some words that are used and that are considering the child as an object. When we talk about placement, at least in French, you place something on the table. It's an object that will place on the table. If you place a child in an institution, it doesn't mean that you will take care of this child and aim to protect the child from a family that doesn't take care properly of this child. So these are some other examples on the effect of using some words and towards other. And I wanted to finally say that we also need at some point to ask children how they want to be called, how they want to be described when they are in a specific context. And I think that having their views and words can also be very important, although it may differ from one place to another, from one language to another. In French, an adolescent, it's not a very negative term. In other language, it may be a negative term. So we also have to take this into account, but at least let's think about what word we are using and why we are using these words instead of others. Thank you.
Thank you, Benoit. I don't know if any of the speaker wants to react to this, and maybe I find it indeed interesting in this moment where, especially in Europe, we are putting quite a bit of emphasis also on the participation of children, on empowering children, strengthening children's agency, how we say it in English, and also the European Union has recently launched a strategy that is now a strategy on the rights of the child at European level that has been done in consultation with children. And so that is actually, there's more and more space given in Europe to the voices of children, and also on governance and advocacy matters. And for instance, I'm thinking, depending on who wants to interact, but Michael, the terminology guide that you have been developing in Cambodia, was it done, for instance, in consultation with children? children? Did you manage? Did you have the capacity? Because I know there's also a matter of capacity to involve children.
Thank you for that question. I'll address that question and then also point off on some of the other comments that were raised so far. For this guideline in particular, specifically, we were not able to have consultations with children, unfortunately. But what I did do was I brought in different experiences I've had over the years in my interactions with the children when developing the guideline itself. So in many ways, the reason this guideline was developed was because of those interactions I had with children in detention settings, in criminal justice settings, in different legal procedural settings. And that kind of led to the importance and the need to develop a guidance of this sort, and to also bring in what it is that children felt more comfortable with. So in that regard, it kind of indirectly fed into the process, but we weren't able to have specific consultations with children on this guideline in and of itself. But I think that's actually interesting because it also segues into one of the other comments about using acronyms for individuals. And this is something that I've also had a lot of different conversations with different colleagues who are for and against it. Of course, it's much easier when we use acronyms. It's shorter. We don't have to use as many words. It kind of facilitates speaking. For example, like children in conflict with the law is a pretty long term. So using CICL, for example, or children with disabilities or persons with disabilities using CWD or PWD. But that actually leads into the disability sector. In the conversations I've had with people in the disability sector, they've also mentioned that they prefer not to be called or referred to as acronyms. And I've had similar conversations with different children I've worked with as well. And I think it's interesting how acronyms can play a positive and a negative role. So for example, the global organization Handicap International, when they changed the name of their organization because they didn't want to use the word handicap anymore, they still kept the acronym HI and changed it to humanity and inclusion. So they were able to keep the branding, their logo, using their acronym, but their full name, they changed to humanity and inclusion. So in some ways, they were able to mitigate some of the branding issues because they did have that same logo with the acronym, but then they changed their full name to be more aligned with what they considered to be more disability sensitive and inclusive. But also, I think similarly, there's the context of how we're referring to these individuals, even if it's not with an acronym. So a lot of the discussions I've had in the disability sector of calling someone like the blind or the hard of hearing, they prefer to be called person who is blind or person who is hard of hearing, person with a disability. Kind of bringing that element of the person first, and then sort of linking it to whatever condition that they may have physically, or how that may be linked to the society and the community that they're in. So first and foremost, focusing on that person element. And I think that's very similar when we talk about the context of children and how that links to whatever different identity that may have or whatever background they may be coming from. And then the other thing I wanted to quickly touch on in terms of gender terms, one of the interesting points that we've also had in different legal contexts was the use of the word, for example, paternity. And when we have sort of paternity forms, which is really kind of focusing on that heteronormative framing of a wife and a husband, whereas it would be much more inclusive if we just use the term parentage, because that includes any gender of whatever form. And so I've worked on different cases where we tried to change the name of even just a legal document form to say a parentage form instead of a paternity form, for example. And then going back to the point that Benoit had made in terms of, in some ways, using euphemism for some of these different sort of structures that may exist. So another term for those detention facilities I've seen very often are training schools or rehabilitation centers. And I think it kind of goes both ways. We definitely want to go in the direction of making sure that these facilities are child-friendly and are based on principles of child-friendly justice. But in some ways, it also detracts from a lot of what may be going on in these structures. And the states may claim that they are actually following the CRC, for example, because look, we have these wonderful training schools and rehabilitation centers for children, when in fact, they actually are just prisons using a different term. So something to be mindful of. But I think just on that last point, and I'll stop speaking after this, on that term of rehabilitation, And this was a really interesting term that came up in the context of our terminology guideline as well. Initially in our guideline, we had a definition of rehabilitation in there, as well as a separate definition of reintegration. But I've had conversations with the CRC committee members about this, and we decided to take out rehabilitation, and we left a footnote linking it to reintegration. And the reason we did that, and as we often know, rehabilitation is often used to describe a core pillar or ideology of criminal justice and as part of the reintegration process. But the exact definitions have not been always clear. And one of the really important inputs that we received on this was rehabilitation suggests a medical model that focuses only on the child to make changes, whereas reintegration indicates a wider set of measures involving the child, family, and the community that are required for children to successfully continue in or re-engage with society and to avoid repeating further offenses after coming into contact with the criminal justice systems. So we decided to take out the phrasing of rehabilitation because it really has to be a wider discussion we're having with different stakeholders rather than just focusing on the child's change. And I think so that terminology, but also in the way that we're thinking about child-friendly justice kind of is very intricately linked and something that we have to be thinking about. Thank you.
Sorry, I had a microphone issue. Yes, Bob, thank you very much, Michael, for this insight. So, Bob, do you want to react to this?
Well, yes, as I think, the point about rehabilitation is something that has come up as the justice system, such as it is for kids, has evolved into a developmentally framed system, is that kids are developing their ability, it's all the time. The idea of rehabilitation really makes no sense in a developmental context. So getting rid of it from the lexicon makes sense in a lot of ways. And there have been advocates in the United States have been pushing along the way that Michael just suggested. But I think that, implied for me in the discussion of disabilities is thinking of language as strategic and political for us. One of the things about the disability movement, both in the United States and worldwide, is that it affects children and adults, so that the political alliance is different than that it just involves children, even though we adults on this call are advocates for kids. We're not as widespread as the disabilities movement, I would argue. The disabilities movement has been ahead of the rest of us in avoiding the labeling. So, in the United States, when we first opened our office almost 50 years ago, we had the the Education of All Handicapped Children Act. That became eventually the Individuals with Disabilities Education Act. The United States adopted the Americans with Disabilities Act because there were adults in Congress with disabilities who understood what was going on. So the choice of language is tied to the political power that we have. And it's one reason that, at least in my remarks, I've focused on trying to be strategic. Where do we have the political opportunities? And I do sort of welcome the point about the nice label, that could hide what we're doing, the training school, or as I pointed out, the Youth Studies Center, which was really a brutal lockup, maximum security facility for kids that was really harmful. So one of the challenges that we've had with language is whether we want to stress sort of the positive aspects of our clients or the horrible aspects of the systems that deal with our clients. So in the child protection side in the United States, there's a movement not to call it a child protection system or a child welfare system, but a family surveillance system, to alert the general public at what's going on in a very different way. So these are all strategic choices about language. And for me, they're much more ad hoc than generalizable.
Thank you. Thank you, Bob. Indeed, I see people. You also want to, I give you the floor to react to these thoughts.
Yes, I just would like to underline one word that Bob mentioned is power. No, we use word to exert power. No, and we can disempower with words. And this is one point, is one of the word I wanted to mention, power. No, the power to shape the discourse. No, is the power of using certain words. I think that in some way, taking the Convention on the Rights of the Child as a cultural platform for analysis in a systemic way can help in saying how much is important this centrality of the power of the child to shape the discourse instead of labeling reality with words. And I would like also to add that it's very difficult to talk about words without considering images. No, every word solicits an image. No, and unfortunately, I was saying that before. I mean, even in the defined child rights community, we have a lot of organizations who are continuing to, for marketing purpose, to solicit images and words that are not really based on the principle of the convention. And I think we take it, as a need, because sometimes showing a child without the story that is suffering can generate donation or whatever. But I think it's very important. We can't consider words in this connection from a multimedia dimension, which unfortunately is proposed by many organizations who are promoting children's rights. So the purpose is different. So there is a need of a kind of coherency that needs to be reestablished. And maybe the next seminar we can do is about how much do images matter, which is very, very much connected with the discourse. Thank you.
Thank you, Pippo. And here, indeed, you're opening as good. I put it down for 2023. Definitely, the use of image, and if we think a bit, how we want to convey messages. I think also about the media again, because it's one of the comments made here by the audience, and how we perpetuate some maybe stigma through the use of image, not just words. If we think of the work of UNICEF, for instance, the way that the imaging has been used from an organization that from the beginning was there to promote the rights of children, but decided to shift from images that were portraying children, let's say in their difficult situations, versus portraying children now that are actually put in a more positive light. So how does it work or not? And I want to I will look also at the panel if any one of you raise their hands. I see that Astrid, yes, you raise your hand. So do you want to share your thoughts about what has been said?
Yeah, but I don't want to interrupt what you wanted to address.
No, I wanted to see if I want to say something, but I like to hear what you say first, and then I wanted to bring a word for you to also comment.
Okay, because what I did want to pick up is, also this point that Bob made on the strategic choice, and I did want to address the term child-friendly justice, as we have been using it now, and we have it in the text. And I think that was also a strategic choice. I'm not 100% sure whether it developed also in consultation with children, but I think the latest, since we have the Council of Europe guidelines on child-friendly justice, it is very established. But I also notice for people who are not working in that area, it's not always so clear to them, and it seems sometimes for some of them too soft, I think. So we always try to say for the understanding is, and this actually comes also from interviews we did with children, what they would understand by it, that it refers so that children can feel safe and comfortable. So they're protected, but they can also participate, to have both components. And and what I also kind of like about this term is that it really addresses children's the diverse roles children can be in contact with the justice system, and the different type of proceedings they can be in, because we also talk then about children in role of victims and witnesses, and this also has a lot of connotations when we use those terms. Thanks.
Thank you very much, Astrid, and for bringing this in, because it's true when I mean, the name of our network is called Child-Friendly Justice European Network, and some practitioners and well, people that have been working in the field for a long time, they say sometimes they prefer to refer to child-centered justice or to, so what is friendly about the system today? So why do we use that? So that is interesting, an interesting discussion to develop. Maybe I wanted to bring a word to you, maybe for the panel to also discuss. And I also encourage the audience to continue adding your words in the Mentimeter. We will also share all of this with you after the meeting. But now if you click on the link that was sent by my colleague, you see already some words that have been put there. And actually the word that I had in mind is there. And also I wanted to share just something in a minute about my own experience by working in Eastern Europe and how important the words and also what the panel now has been referring to as the action that is being done, and also the willingness of policymakers and practitioners is in doing the right thing for children behind certain concepts. And here I want to give just one example around deinstitutionalization, which is already a word that is very hard to pronounce. But in fact, getting children out of institutions, as we know in the Eastern European context, it has been a big challenge. And one day I was in front of a mayor that was actually very proud to say that, yes, we do deinstitutionalize children, we have developed various services. So on paper, it did look like, and in the way that the concept was described and written, that children were put out of big, large institutions because children used to be in places where there could be 600 children. We're thinking here about Moldova, about Romania, for instance, Bulgaria. And then we visited this center, and what actually this place, this service municipality had done, they had left the children in the same building, but they had called the third floor and the one corridor in the third floor, the family home. So the children were placed, and sorry, Benoit, I'm using that, but this is how they were placed in a family home that was actually the same building, but on the third floor. So there is also the discrepancy between what we say, what we speak, and what you actually see in practice, what is being done. And there was not willingness of that mayor in this case he wanted to deinstitutionalize, but also maybe to accompany the explanation of certain concepts. That is also very key. And the word that I would like to bring to you, which is then a word also from the audience, is deviance and deviancy. And why I'm bringing that word is because also in Europe, and my experience in Moldova, and the legislation now in Moldova uses in the text, and there was also quite a lobby from an advocacy work to upgrade the legislation for children in conflict with the law, because they refer also to that terminology there, and the legislation referred to deviant children. And so, despite the lobby of the child rights civil society, the government decided to maintain this word and to actually try to come with a more progressive legislation, but using some word that could be also very qualifying the children negatively. So I don't know if the panel, you want to actually say something about that. Is that yes or no a stigmatizing word? I don't know who wants to react to that.
Well, if deviancy or deviance, yeah, I would think absolutely it's stigmatizing. I can't think of an example in my memory, at least in the United States, where even people with whom I deeply disagree would use that word to describe. I mean, they've used horrible words to describe children who have been involved with the system, but not that. So, but again, I think the larger point here that you're raising it to is that words mean different things to different people. And I think, Michael has mentioned that earlier, as all the panelists, is that I find myself in conversation with colleagues, either in other jurisdictions or with people who are much younger than me. And we're often using the same words and talking about something entirely different. So, what I'm hearing is that the people who are proposing deviance or deviancy in what you just described may have a very different view of it than I would, as I see it as highly pejorative and would never use. I don't know anybody in the United States who would use it.
Thank you, Bob. Benoit, you also wanted to react?
Yes, but it was exactly in the same way as Bob. I think that, yeah, for me, it's also very stigmatizing to use deviance. It's really as if we have one real path that all children should follow, and someone who goes on the side is not in the mainstream and will be seen as as someone who is stepping out of the society. And so we really want to show and to make it clear that this child is not part of the society. But also, I think that very often in the field of justice, we use, and it was already mentioned, but words coming from the health system and also the mental health system, describing someone who is not behaving in the right way, which is accepted by the society, as someone who has per se mental health problem. So using one specific word which has a meaning in one specific context and using it in another context is also may also be very stigmatizing. So but in addition, I would like also to say, and Bob mentioned that talking about generation, I think that when people started to talk about juvenile justice, it was already seen as a progress, because before it was just one justice system for everyone, children and adults. And when a specific system was created for younger adults and children, juveniles, it was seen as a progress. But later on, probably it's not seen in the same way. So I think that over the time, words may change, the meaning of words may change, and also we have to also adapt our language. This is also why the Committee on the Rights of the Child had to change in maybe more than 10 years' time, from juvenile justice system to child justice. So it shows also that it's not static, and we also have to take into account how time has an effect on all this. I wanted also to talk about the word alternative, but I keep it for later.
Thank you, Benoit. Maybe we have time still to talk about alternative, but before the panel, does anyone wants to share? I'm looking at the little screens. No sign at the yeah, but Michael.
Yeah, I'll just quickly touch on 2 points. So in terms of deviancy, yeah, I consider it to be very similar to delinquency. And obviously in the context of the United States, the delinquency cases or delinquent is a term that's also used in the law, very similar to juvenile courts, etc. And we know that the 1990 Riyadh guidelines also uses the term juvenile delinquency, which of course over time we try not to use, but it's still there in the law. And so I think very often it becomes very difficult to change the terms that especially lawyers are using, but also the general public is using when we unfortunately do have to refer to what is listed in the law. So fingers crossed that you may have further luck trying to change the legal terms going forward for deviancy, delinquency, etc. Also, just the other point, I know we talked about child-friendly justice, but also the term child justice in general. That term has been used in a lot of different ways by different people I've spoken to. But some people speak about it in a very sort of narrow terms in terms of looking at children in conflict with the law and sort of the different systems and procedures that are related to the criminal justice system and the administration of justice. Whereas I know a lot of advocates these days use it to be a larger concept that encompasses access to justice for all children in all its forms, including criminal, civil, economic, social, cultural, environmental justice, etc., which I know a lot of people also refer to as justice for children or justice with children, that the Global Initiative on Justice with Children also pushes for. So I think even, that term, that's something that we would think might have a common understanding among people, very often we are speaking of different things. So that's something to be mindful of.
Yeah, thank you, Michael, for this. And while you are actually sharing all this, it's actually very already thinking how interesting it's going to be to compile this in our little reports after this, because it's going to, I see this really as food for thought, because of course we don't come with any solution and, oh, we should use this term and that term. And I think what comes out of our reflection today is also the importance of the evolution of the rights and of time, and how at one moment certain of time a concept has been used, thinking in that context it was progressive, it was something that was breaching from maybe a negative pattern, but maybe with the time it became something that needed to evolve. I see in the meantime that the audience has also been very active in the chat. There is, we started, if you remember, with the sharing about this publication about children of imprisoned parents, and our friends and Paula in particular from Children of Prisoner Europe shared an interesting resource on their work on advocacy that also reflects about the use of language in this case, and some other comments about also the use of thinking of deviance, the use of behavior change, and that is actually still used in very country. And so in a comment that is a bit about thinking of how to treat children in the justice system, and that echoes a bit also about maybe with Benoit, the fact that some concepts that are used in a maybe particular field of work that are then maybe used in the context of child-friendly justice that might maybe be taken with another dimension. So I also wanted to share with you here just a few words. I mean, you can click on the Mentimeter if you want a visual of the cloud that we are doing, but some among the words shared, they are vulnerable. Of course, we spoke about child, alternative, Benoit's mentioned that, children in migration, placement, power, agents of change, victims, minor, and there will be other words that we have talked now that we will add to this cloud, so you'll be able to also see the fuller picture, the one that has been shared by the panel. We haven't introduced them yet, but maybe before we close, I don't know, Benoit, if you win, I give you the opportunity to share maybe something about alternative. So not to leave this this meeting, we still have some minutes, but to maybe say something about alternative, which is also something that is quite a hot topic in the area of child-friendly justice.
Yes, but just before, I wanted also to mention that when we use now child justice, it may also be confusing, because we are using it in the frame of this General Comment 24, which deals precisely with children who are like we said before, in conflict with the law. They have committed or they are suspected of committed an offense. But child justice was also a word, or is also a word, that is used for other situations where a child is in contact with the justice system. So maybe in civil proceedings, in administrative proceeding, are as claimant, or a justice which takes into account the needs and rights of children. And so there is a risk now that when we will talk about child justice, we will reduce this terminology to the situation of children that are in contact with the justice system because of an offense. So just to keep this in mind, it's not an easy question. How should we deal with that in the future? When it comes to alternative, we tend to use alternative in many different ways, in many different situations too. Alternative is the situation where you have two choices usually. And we will talk about alternative to detention, but as if the alternative is the second option. The first option is detention, and the second option, in some case, when the child is lucky, or I don't know for which reason, one will choose the alternative. But this is exactly the contrary that the Convention on the Right of the Child says. The Convention says detention should be of a last resort for the shortest period of time. So the alternative should be detention. The main road is liberty. it's avoiding using deprivation of liberty. But in some case, we need as an alternative to use deprivation of liberty for very specific reasons. And so the same with alternative to judicial proceedings. When we talk about diversion, diversion is using or using other procedure outside of the formal justice system. And this is also seen as an alternative, while again, we should only use the justice system when there is no possibility to deal with the situation of a child outside of the justice system. So we should also keep this in mind, because it may imply that the main and the most important road and solution proposed to a child is, as a matter of fact, contrary to their rights.
Thank you, Benoit, for bringing us this perspective, indeed, of a term that is very much being used and being promoted around in the area of child-friendly or child-centered or child-focused justice, as Michael has shared in the chat. I'm looking at the time. Of course, we will need to wrap up. But is there any of the other panelists that would like to share a very last thought? Yes, people?
Yeah, just, I mean, words are the result of a paradigm, the cultural paradigm. I mean, it's not by chance that we are using certain words. You were referring to deviancy instead of talking about or mentioning the deviance of the system. We are referring to the deviance of children. So I think in some way, just a shift of paradigm could help us in finding new words. Because sometimes, I mean, the risk is to remain in the same kind of system. So I think that change could happen if we question why our paradigm express reality with certain words, and what is our interest in expressing the reality with certain words that might not be appropriate. So in some way, I think words are counting, of course, they matter, but at the same time is the use of words can suggest us, what it has to be changed in our cultural paradigm against childhood or justice for children, or whatever we would like to call it. So it's just a general note, but I feel really these needs of expressing, something that I think is urgent also in the child rights community, like what really we haven't considered in terms of shifting this paradigm that continue to produce words and images that might be politically correct, but in some way they remain in the same system and disempower children. Thank you.
Thank you, people. Any other panelists would like to say a last word? No, so I will first thank very, very much all of you from the panelists, each of you with those very interesting insights that you share with us. This was a bit of a challenge to organize this webinar, only because we knew that this theme was going to be quite dense, and we hope that we managed through this hour and a half to bring to the audience some aha moments about what are the words that we are using, which words are we using, do they matter, and how do they matter, and what am I as a practitioner doing in order to perpetuate maybe better practices for children, or am I actually, by using certain words, perpetuating, stigmatizing maybe a language without sometimes having the awareness of it. So we heard today that it is important, of course, in whatever we do, whatever language we use, that children feel safe and protected. So it is important to use certain words. It's important that by the uses of these words, children can feel safe and protected, because children are at the center of justice. We heard also that the context is very important. We spoke about the cultural context. We spoke about the language, the translation of certain concepts, some concept existing in a language that is translated in another language that could bring a stigma when we're using the translation. We spoke about, okay, it's important to talk about words, but what is more important is the action. That is not an empty shell behind a word, a concept without content, but to actually really make sure that the services that children receive are actually services that do well for children. So we spoke about the role of advocacy, the role of media in perpetuating maybe certain languages. We even evoked some images that are linked to the use of language. And Bob also was reminding us the importance of strategic and the political context that language can bring us to be even more strategic in the way that we intervene in this area. So by closing this in thinking a bit about this, what words do we use? We have the audience sharing with us quite a few words, also very interesting, and thank you very much for having been such an active audience. We have recorded, as you know, this discussion, so we will be sharing the recording to people that are interested. You will receive an email with a link to the recording and also a short report summarizing a bit to also food for thought about the different concepts that were discussed today. And we see here that some people in the chat are sharing some of their contacts. We're taking note of that. And please do not hesitate to subscribe to our newsletter, also from the Child Friendly Justice Network. You can find a link to subscribe to the newsletter on the homepage of the website. So maybe one of my colleagues can put here the link of our website. In our newsletter, we share this sort of events such as webinars or other publications in the area of child-friendly justice, case law from international European courts of human rights. So we really want to create an active thinking world, let's say, from child-friendly justice practitioners. And we like to hear from you, also the people working directly with children. If you have feedback about how the network can be useful to you, we are more than happy to hear that. So thank you, everyone. Thank you very much to the panel. And I wish you a very good end of year. The festivities, if hopefully you are in the consent that you can do some festivity. It was a particularly challenging year, especially for children in Europe. So we are very aware of that, with the current context, from the energy crisis to the war in Ukraine and other tensions. So we hope that we can at least be a bit safe around our friends and family and be recharged for next year, and make sure that next year we can do even better for children that are in contact with the justice system. So thank you very much for your attention, and be safe, all of you. Bye.
Thank you. Bye-bye.